All right, guys, 7:05, so evening. So first things first, this is now our fourth class. It won't be nearly as long as Tuesday's class was. The material isn't as extensive as that was. So we'll be done, I would think, before 8:30. So there we go. You will have already noticed if you look at your grades on Moodle, that you'll see that there's now a number of grades for participation and for in-class exercises. So the participation fundamentally is what we do at the beginning of the class. So you would have seen that from, for instance, last class, if you asked a question or had a comment, that kind of thing, then your grade would have been recorded as, went from an 8, which is what you get for just coming to class, to a 9, and actually there was a couple of 10s. So you'll see that in your participation grade. And likewise for in-class exercises, that is those are the breakout questions. Everybody's doing a really great job with those. So as long as you keep that up, you'll continue to get 9 out of 10 for that part of your grading. So for this kind of class, I treat this as a seminar, which it is. Anything less than 30 students is a seminar, and I would think in real terms, the class average will be in the low 80s overall. That's taking into account how you do on your midterm and your final exams and your group presentations. And I'll say a few words about that at the end of the class. Yeah, the grades will vary in this class somewhere between 75% and 95%, which is great. You know, almost all of you will get an A in the course unless something seriously goes wrong, and I don't expect that. So just keep it up. The participation is fabulous, so I'm really pleased with that. So to start it off, all right, so what I posted for you yesterday was 2 things relative to this class that's basically on an asynchronous basis. The first thing was a PowerPoint that I prepared for a class that I do on the United Nations. So it was basically an introductory to the United Nations. It gave you information with respect to the establishment of the UN, the organization of the UN, which is also talked about in chapter 4 for your readings tonight, and what the UN can do. And I gave you in the PowerPoint some very specific chapters of the Charter for the United Nations, which sets out basically the authority it has with respect to the 193 nations that belong to it. The second thing I gave you was a YouTube video on the International Court of Justice. We'll touch upon that tonight. Again, that's also in your textbook. And that is the primary vehicle for disputes around the world between states. And a lot of environmental jurisprudence internationally has been before the ICJ. All right, so I gave those 2 things for you. I mentioned to you that if you looked at the PowerPoint and you watched the video, you know, I'd be looking for questions or comments from anybody at the beginning of the class. So if anybody has something to say, which obviously goes to participation, then raise your hand or speak out. Kate?
Hello.
Is that you just joining, or you want to say something?
That was just me joining.
Oh, okay, no problem. Okay, again, so does anybody have anything they want to say about the stuff I gave you in the UN and or the International Court of Justice? If not, I'll just move to the lecture. So, anybody?
Yes, sir.
Oh, Alexi, okay.
Hi, sir. I was basically like doing some research, like when I read the document, and then I saw like some critiques where they're saying the model UN is not as effective as like the mottos that they put out to the world. What is your opinion on that? Because I personally think like every organization, they can definitely do more to improve, but is it safe to say they're not working to the best of their ability to solve like the issues they block?
Yeah, good. It's an excellent question, and it's at the core of how, to some degree, the UN has become dysfunctional. And the reason for this is this. So when Franklin Roosevelt, at the end of the Second World War, he died in 1945, just after he did this, when he put the United Nations together with about 80 or 90 nations at the time, and I mentioned this last class, what happened was that the 5 principal allies after the Second World War the Allied forces versus the Axis forces, which was Germany, Italy, and Japan. But the Allied forces, the main countries were the United States, United Kingdom, Russia, China, and France. Although I don't know why France was actually there, because France was conquered by the Nazis within about 2 weeks after the start of the war. But having said that, those 5 countries have become the what are called the permanent members of the Security Council. So the United Nations operates essentially as a body, which is the General Assembly. So think of this, it's not comparable, but it gives you a bit of an analogy. Think of it like Parliament. So Parliament in Canada is 338 members of Parliament who are elected from across the country. So the United Nations basically has a General Assembly, which is made up of 193 members, and they have people who actually, and obviously somebody from each one of those countries sits in the General Assembly. But the General Assembly is not, for the most part, a lawmaking body. We'll talk about this later tonight. It's not a lawmaking body the same way that, for instance, the federal government in Ottawa is. But it is a body, and it's a body that, basically is at the heart of the United Nations. But the real power in the UN is with the Security Council. And the Security Council is made up of 15 member states, taken out of those 193 other members, but 5 of those are always, right, and this does not change and has not changed since 1945, are those 5 countries I just mentioned to you. So they're permanent members of the Security Council. And the problem that has come to be over the course of time is that these 5 members of the Security Council have a veto, right? And they have a veto, and it's an unquestionable veto. They don't have to justify how they exercise it. They can just exercise it. And so anything that, and the Security Council is like the cabinet in Ottawa, right? It is the far and away the decision-making body of the UN. So what's happened over the course of the last 70 years is that a number of disputes have given rise internationally, particularly, for instance, things like, you go back to the 50s and the Cold War, between the United States and Russia, which was continued into the fight between capitalism and communism in Vietnam. The problem that the United Nations has, and those are just early examples, is that when issues, for instance, like Vietnam, came before the United Nations seeking resolutions, the resolutions put forward, if they weren't in favor of the United States or the American position, they would veto the proposals being put forward. Or likewise, and their proxy was South Vietnam. So the United States supported South Vietnam. So something was put forward, on behalf of the South Vietnamese people. It was vetoed by, for instance, Russia, or China. They were, you have a veto. So that's the problem, is that, and so for North Vietnam, they'd be proxies for China, for instance. Anything that would be contrary to the interests of North Vietnamese would be vetoed at the Security Council. And that has just continued throughout time. So, that is the fundamental reason why a great deal of the things that the UN could have done to address international difficulties, battles, fights, whatever it is across the globe, is that these 5 members of the Security Council have a veto, right? And so, and they use those vetoes through their proxies for countries that they support. And in the 70s and 80s, for instance, a lot of that stuff, there's a lot of fighting in South America. And almost every country in South America was either allied with what was in the Soviet Union, now Russia, or the United States. So getting things done has become very difficult. So they have come together to get some things done, but the veto power of those of the permanent members of the Security Council are what stand in the way. Does that kind of answer your question, Maxine?
Definitely, really does. Thank you so much.
You're welcome. Thank you. Anybody have anything else?
I have a question that kind of piggybacks off that.
Sure, William.
With the 5 Security Council that you said there, is there any way that the UN could impose like that they get rotated out every so often, or that there would be no Security Council at all? Like, have there been talks of that?
there's been lots of talk about that because everybody recognizes that issue that I just said. And there's been talk, for instance, that, in the real world scene in the last 20, 30 years, countries like Germany and Japan, which have been powerhouses economically, but who were enemies at the end of the Second World War, should really, they have as much right to be on the Security Council as would France, for instance, or even the United Kingdom. The United Kingdom has, as a dynamic a nation as it was going into the Second World War, was devastated after the Second World War, and it's no longer a world power, although it was a world power for centuries. And we talked a lot about that last day, dealing with indigenous issues. So, there's every reason in the world to think that a country like Germany should have a position, at least equivalent to France or the UK on the Security Council. That it makes no sense, in real terms, economically, politically, what have you, that it wouldn't have that kind of position. But it would only happen if it was unanimously agreed to by those 5 permanent members. That's as in they all have a veto that is unquestionable. So unless they all give up that veto in order to allow either one of them to go off the Security Council and be replaced by somebody else, and that'll never happen. The best thing that and this has been proposed is to, for instance, expand the number of members of the Security Council. So take the original 5 and then add countries like Germany or Japan, or any other nation, Australia perhaps, that could take their place. But the problem with it is that those 5 vetoes have to be put aside in order for that to happen, and that's just never going to happen. Realistically, none of those 5 members are going to give up their veto rights, and they don't want to give other parties veto rights because that just complicates the thing. I mean, the Security Council itself, again, is 15 members, right? So there's 15 votes. But 5 of them are permanent. Canada has been on the Security Council 6 times in the last 50, 60 years. The last opportunity for Canada to be on the Security Council was 2010, and the Harper government, it wanted to be on the Security Council. It was the first time that it actually indicated its willingness to again be on the Security Council, and the United Nations rejected it because Stephen Harper and his conservative government of the day was not a supporter of the United Nations. They did a number of things to take Canada out of various covenants and conventions of the United Nations. So Justin Trudeau, for the last 2 years at least, has spent a lot of time on energy on getting Canada back onto the Security Council, which vote takes place next year. We're competing against Ireland and I think Ecuador for the one open seat that comes up next year. And so you see Trudeau does a lot of publicity now on the world stage, trying to position Canada as the country amongst those 3 that should in fact now be back onto the Security Council. But there we go. But yeah, William, so the answer is yeah. A lot of people have looked at the constitution of the Security Council and changing the way the permanent vetoes work. But again, nobody's going to give up a veto for that to come into the reality of things. Okay. Anybody else? Any other comments or questions?
Yeah. Can I go? All right. So my questions kind of fall from the 2 previous questions. It touched a bit on it from that last answer I gave. But I'm thinking reform for the UN as relates to the members and how they currently operate. I think now the UN is somewhat crippled and unable to perform most of the tasks outlined in Article 1, which is to preserve peace and stop aggression from nations, right? Where we find nations on the council, particularly US, is a source of many aggression towards other nations, but they go unchecked because of the superiority and the amount of power they wield within the UN. And to touch on the nations that are the permanent members, I'm arguing that, or I think this is why those nations are there now, as you can correct me, coming out of the war, where Britain, France, and US were all allies, and you had Germany and Japan, and those countries were on the other side. At the time, there was still bad blood between those nations, so they weren't favored to be a part of the Union. Russia merely got in because in the end, there is some cooperation there after they were struck by Germany. So again, this argues reform. The landscape of the world today is different from when we came out of World War II. So I think it's about time that we relook at the structure of the UN and also put ourselves in a better position to hold some nations accountable, because the UN is failing us largely, I would argue. What are your take on that, Miles?
Oh no, it's exactly what you're talking about. It is failing us. It's not doing things that it should be doing, and even when it's not an issue of the vetoes. For instance, the war in Bosnia in the 1990s, where Dallaire, Canadian general, was in fact the head of the UN mission in Bosnia. Even then, and it wasn't a proxy battle between the veto powers. It was basically a lack of inertia by the United Nations itself to answer the call that Dallaire put out, saying, "Look, these people are killing each other. It's a genocide, and it's going to get a lot worse. Give me more UN peacekeepers." To help out, and the UN ignored him. And as it turns out, there was a bloodbath, and it damaged Dallaire. He openly admits that he had PTSD after being the head of the UN mission. And that's unfortunate. And peacekeeping, which people see in the UN as being one of its fundamental purposes, it is, because you think of it, how important it is to keep peace in the world. Although it's actually a relatively small part of the operation of the UN. Until recently, Canada only had 20 or 30 actual peacekeepers working around the world. Trudeau has boosted that number a little bit recently, so I think there's now about 150 peacekeepers. But for a country the size of Canada, and as important it is for Canada to see that it's a world leader in peace, that's not very many. It's really not. And peacekeeping at the UN, as a matter of fact, was a function of a Canadian Prime Minister, Lester Pearson, in 1956, who was at that time the Minister of Foreign Affairs in the Louis Saint Laurent government. He was a Liberal. He basically resolved the Suez Canal crisis, which was an incredibly stupid battle between Great Britain and Egypt over access through the Suez Canal. The British government built the canal, and Egypt closed it off from their access. And so Britain wanted to go to war against Egypt, which nobody supported. And Lester Pearson, basically through the UN, negotiated a peace, and that got him the Nobel Peace Prize. And the next year he became Canada's Prime Minister, and that really was the beginning of peacekeeping at the United Nations. But it does some decent work, but even then, a lot of the criticism of the UN in the last 10 years deals with peacekeeping, because there's been a lot of problems with peacekeepers who go into these countries, third world countries for the most part, and commit a lot of sexual abuse and rapes and what have you. And the problem with that, obviously the problem with that is it's horrendous. But these peacekeepers aren't subject to any laws, right? They're an organ of the United Nations, but there is no criminal code, for instance, to which people can complain when they take advantage of the women and children in the villages to which they're supposed to be protecting. So, yeah, the UN, in a lot of respects, is not doing what it should be doing. Anything else, Red, or anybody else?
Hello?
Tyler?
Is this working? Hi. Yeah, this is just a brief question. I was just curious what the status is, or the current status of their contribution in general to the UN with regards to Russia since succeeding the Soviet Union's permanent seat. Do they still contribute to the UN in any way? If I'm not mistaken, I remember this being a topic that has been discussed in the past within the past decade, and I'm just trying to actually understand what their status is with the UN at this
Oh
time.
yeah. Everybody contributes to the UN, and it's supposed to be a function of their gross national product. I think it's supposed to be 1.5 to 2% of their gross national product is supposed to go to the UN to fund it. That doesn't happen. Even Canada doesn't live up to that amount, but Russia makes its contribution. It is a permanent member of the Security Council, so it does. The US has traditionally been a prime financier of the United Nations because it sees it as a prestigious position. However, Trump doesn't. Trump's not a supporter of the United Nations, and just like when he defunded the World Health Organization, he threatens to defund the UN all the time. So I don't know of any, and maybe Tyler, you've seen it, and I haven't. I don't know of any anything lately I've seen that says that Russia, as a contributor, to the UN is looking at defunding it or reducing its contributions. I don't know.
Okay, that's what I was curious about, as to whether or not they were still. Yeah. Okay, that answers my question.
All right. Cool. All right, guys. Anything else?
I had a question, actually. It was just to kind of follow up on that. The one before Tyler, you said that there's no real rules or regulations for like peacekeepers or anybody in the UN who goes into other countries and, rapes and abuses the locals or whatever. Is there any plans to implement anything like that, or are they just kind of letting it, whatever happens, happens?
They're not, they can't change the environment in which it takes place because they have immunity, political immunity, as members of the UN going into these other countries where they're ostensibly supposed to be safekeeping people. So they can't be charged internally by those countries. But there was about 4 years ago a study internally in the UN trying to address this issue. And basically the end result of it is that there should be best practices put into place and sensitivity training put into place for peacekeepers so that this isn't something that they do, although I don't think that would necessarily be that effective, but that's about as much as they can do. They can't be charged. They have political immunity. So it's not a nice answer to that question.
Thank you.
Sure, Valerie. Anybody else?
I think
again. Sure.
I just wanted to add even quickly. We had a similar incident back in Haiti where some peacekeepers were actually brought back. I'm not sure the country, and they were removed from Haiti after they were accused of engaging in exploiting the locals there. Another situation, but I'm not sure those persons were actually prosecuted, but they were actually removed, and the UN conduct was subject of some extensive investigation. I can't say what was the final result of that though.
Well, I mean, I don't know of any successful prosecutions against peacekeepers. 1980 is probably what used to be Czechoslovakia. I don't know of any successful prosecutions. While it's certainly more well known than it used to be, and certainly frowned upon by everybody, it still takes place, and there's still no punishment, really. But thanks again for that. Anybody else? All right, guys. So, all right. So let's thank you very much. Again, you guys are doing a great job, participation. So thanks very much. So let's go to the PowerPoint for tonight. So this won't take a great period of time. There's a YouTube in the middle of it kind of thing we're going to watch, and then we'll do the breakout questions, which as you guys know, I posted on Moodle yesterday. All right, so again, we're dealing with the international context. So as you can see, the first couple of weeks, the first two classes were very broadly based classes, giving you, well, the first class was just introduction, but the second class gave you the constitutional context of how laws are basically put into place in Canada, and the division of powers between the provinces and the federal government, and all those kind of things, which determines which level of government can pass laws primarily dealing with the environment, of course, for this class. And so that was the first week, and last week or this week, it's still a broad context kind of thing. The reason we dealt with Indigenous issues on Tuesday is because, again, they are broadly based and constitutional to a great degree as well. So it's Indigenous law is seen to be somewhat of a separate kind of, well, actually now we know Aboriginal law is seen to be a separate species of law, and in the context of the environment, there's various distinct issues that are relevant to Aboriginal law. And as a matter of fact, the group question that I'm going to post tomorrow on Moodle, and I'm going to talk about the groups tonight, but the group question is going to be dealing with an Indigenous issue. So, that's again context. And tonight is the international context, which gives you an overview of how environmental laws are promulgated across borders and fundamentally through agencies such as the United Nations. And it's not the only one, but it's certainly the oldest existing one and the broadest based one. And then next week, the first class on Tuesday, it's going to be the first class on regulatory regimes. Regulations are highly important in environmental law because it's the nuts and bolts of how environmental laws are put into place. A week from tonight is your midterm exam. You'll have the whole class for it. You won't need certainly the whole class for it. There'll be 50 or 60 questions. There'll be multiple choice and or true and false. And I'll give you probably a couple of hours for that. And again, you'll get it done before then. And then the next class after that is a return to regulatory regimes. And then following that is environmental assessments. And then we're almost done, right? I mean, after tonight, 1/3 of the course is finished. We're 2 weeks into a 6-week course. So it kind of goes pretty fast. All right, so let's return to the lecture tonight. So it's international context, right? So, international law, the nature of international law, it's pretty much a commonsensical kind of thing. It's essentially a collection of rules, laws that govern countries. It's really important to remember that international law is based upon the first chapter of the United Nations Charter, which indicates that states are sovereign entities. All right, so while we're talking in the broad terms about laws that states may have to adhere to with respect to their relations with other states, that is secondary, fundamentally to the premise that states are sovereign and that they can do what they want fundamentally within their own boundaries, right, and sometimes beyond. So those are important premises to remember. Basically, international law has no legislature, so that again goes back to, for instance, the General Assembly of the UN. It's not a legislature like the federal government has Parliament in Ottawa. It's not a legislative assembly as such, so that again. With the passing of laws is not nearly as clear cut as it would be if you were in the federal government of Canada or even the provincial government in Toronto, right? And the UN doesn't have a police force as in United Nations Police Service, like the Sault Ste. Marie Police Service or the RCMP, that kind of thing. The closest it has to a police force, again, are the peacekeeping missions that we just talked about, and we talked about how ineffective they can be. All right, so you have what's called conventional international law. Conventional international law being law that has been over the years recognized as a fundamental way to put laws into place that do have an effect across borders. So they can, international law is going to be established either bilaterally, which is between two states, or multilaterally, which means more than two states. So it could be 3 states, it could be all 193 members of the UN. And they're basically brought into being by either a treaty or a convention, right? So treaties, the Treaty of Paris is a famous treaty, and probably the most important convention that the UN has ever passed. It passed what's called the International Convention on Civil and Political Rights, passed in 1966, adopted in the next 10 years, including Canada in 76, by virtually every member of the United Nations. And that's the convention that basically said and still does that every nation belonging to the UN has to put into place a human rights document, right, that is constitutionalized. and that was the motivating provision internationally that led Pierre Trudeau to bring into effect the Canadian Charter of Rights and Freedoms in 1982. All right, so treaties, conventions are like contracts in that parties sign onto them, right? And so, they're incredibly important, and that's why they're binding. And we also have what are called protocols, which are less formal and less binding documents, because while you can agree to a protocol, it doesn't have the binding effect of a treaty or a convention, right? So treaties or conventions are created by international bodies, right? Like the United Nations, doesn't have to be the UN, but it most likely is going to be. If successful, they're drafted, they're signed by the parties. The agreement itself will take effect once whether it's a quorum, which is 50+1, or whatever number of states the treaty itself or the convention itself says has to sign on, does in fact sign on. And when that happens, it's called a ratification of the convention, right? And then countries from time to time meet to review the process on moving along to ratification. The framework of international conventions, so the conventions themselves, very much like the ICCPR, will set out what the purpose of the convention is. It'll set out what the obligations of the parties are. So for instance, in the ICCPR, one of the articles, Article 2, actually says very specifically that if you sign this convention and it's ratified, you have to put into place in domestic law a human rights instrument, right? So when Canada signed on to that in 1976, right, and Trudeau was the Prime Minister in 76, that very specifically started the ball rolling for the enactment of the Charter within the new Constitution Act 6 years later, right? So the ICCPR very specifically said, this is what you have to do as a country signing on to it. There are reporting obligations in the convention, which basically means that countries, have to, there's a record kept of how well countries in fact do follow up on their obligations. So there would be a record kept under the ICCPR as to which nations do and do not constitutionalize human rights. There are dispute settlements and compliance mechanisms. So for instance, the ICCPR, and this is really interesting because, and important to remember, that when these things go in place, they not only create obligations of the states, the countries that sign on to them, but it also provides a mechanism for citizens to take a country to the United Nations on the premise that they haven't lived up to their obligations under the convention, right? And so what we have for the ICCPR is what's called the optional protocol. So the optional protocol is a process very much like a court process where you file an application. So it's very much like filing a statement of claim. You file this application to the United Nations. You say that the country you're in, Canada, has not lived up to some specific provision in the convention, and it's harmed me as a function of that, and that you will actually get a hearing at the United Nations. It's actually, even before COVID, it was done remotely to a great degree. You usually didn't have to travel to The Hague to have the hearing heard. But having said that, or sometimes New York. But having said that, a panel of UN states will sit as the hearing panel for the convention, and they will hear the application. The state who is complained about will get the opportunity to respond to the allegation, and if the panel determines that in fact, yes, this country has not lived up to its obligations under the convention, then it will draft and put into place a directive to that country to in fact live up to its obligations. The only difficulty with that is, and again, we're still talking about things involving the United Nations, is that it's not obligatory. It's an obligation, but not obligatory, in that even when the United Nations tells a country that it hasn't lived up to its, it hasn't lived up to what it's supposed to live up to under the terms of the convention, the country doesn't have to do it, right? There is no mechanism to put in place where, in fact, the country can be forced to do something that the United Nations, the hearing panel, says it has to do. So again, it's very much goes back to states, are sovereign states within the realm of the United Nations, and it has no lawmaking power to a great degree. And so, even decisions made by panels that clearly state, and this has happened, Canada has been told on a number of occasions that it's not living up to its obligations under the convention, and directly told, and this is how you do live up to those obligations. So they actually put recommendations in place, and the government of the day ignores them. So there we go. We also had, so that was conventional international law. We now have customary international law, which is simply the evolution of custom that's taken place over the time that a certain international body's been in place. So what it simply does is it's a collection of customs that evolve into rules that are accepted by states to be effective laws, as in they follow them. But again, there are very little recourse if they breach them. So to be a customary law, it has to be opinio juris, which is Latin. It means the states must recognize that the rule of law is to be binding, is in that they are supposed to follow it, right? And that states must follow it. So these rules do climb to as close to becoming an enforceable law as we get in the international context. So we have a number of these rules. You have the good neighbor rule, which simply means that a state is not to cause damage to the environment of another state, right? And if it does, there's going to be consequences for that. You have the duty of equitable utilization, which means that there should be a fair sharing of resources that are shared by countries or outside national boundaries. This applies a lot to the law of the sea, right? And there's a bit of that in your textbook for chapter 4. Right, the law of the sea, basically countries used to only exercise authority within 2 to 12 miles of their coastlines, as we're dealing with oceans. Now most countries have a 200-mile limit, but having said that, they overlap with other states depending on the configuration of the landmass. So this is where the duty of equitable utilization comes into effect, where they overlap. You have the duty to notify and consult, which sounds very, very similar to what we spent a lot of time on last class with the duty to consult and accommodate Indigenous rights. Well, this is very comparable. The duty to notify and consult states that you are going to, if you're a neighboring state, going to undertake an activity that may well cause harm. And so if that's going to happen, you are obliged to notify the state, and you're to notify them, of course, what the potential harm may be and how you're going to address it, right? So that's the equivalent of accommodation under the DCA for Indigenous rights. And then we had the precautionary principle, and I talked about this in one of the first classes. This is a very early rule in international law that simply says that even when science isn't quite advanced enough to be absolutely certain that something may take place that may harm the environment, for instance, so even if there is scientific uncertainty regarding something, decisions should still be made that will reduce or diminish a potential risk or impact. Okay, so who are the players in international law? And we've talked about this at length now. So you have the United Nations, right? So we know how, what that is, right? It's created as a forum for countries to resolve disputes. That's a fundamental purpose of it. Countries can vote on resolutions. Resolutions are put forward. So resolutions aren't treaties or conventions. There's certainly resolutions put forward like motions in a committee meeting. They're not binding and not considered international law, but they're put forward by the body, and the parties can agree to them or not. Right? But if the same kind of resolutions are put forth over a considerable period of time and seem to be adopted on a regular basis, then it becomes what's called an international norm, which is, getting to, close to becoming a rule that may well be enforceable. Again, Security Council is the power at the UN, 5 permanent members, 10 members, making a total of 15 members. And they can impose economic sanctions or authorize military intervention, which again is going to be peacekeeping to a great degree. And we're going to talk a lot about these tonight, we have agencies of the United Nations, for instance, UNEP, United Nations Environment Program that implements a framework for protecting the environment worldwide. So we have a bunch of those I'm gonna talk to you about tonight. The International Court of Justice. So if you've watched the YouTube video that I gave you, it's about 18, 20 minutes long. It was a really good overview of the ICJ, how it operates, the constitution of the court. It is the primary judicial institute of the United Nations. So you think of it as the United Nations Court of Law to a great degree. It is there to adjudicate disputes between member states, right? So any member of the UN can bring an application to the ICJ saying that, you know, this other country is causing harm in this way, and that's how disputes come before it, right? And as long as the parties agree to it, oh, Aret's raised his hand. Aret?
Yep. A question as to how this court operates, right? Seeing that it's an international organization, it does not undo penalty in a criminal sense, right? I know you just mentioned just adjudicate issues, basically facilitate negotiation or that sort of engagement versus passing judgment, right? Or do they have the ability to pass judgment, seeing that it's an international body and there's no true sense of international law?
It does pass judgments, and the judgments are binding because the parties agree that decisions of the court are going to be binding. So they self-regulate in that regard, and it can pass judgments relating to things that most particularly things like breaches of treaties, breaches of conventions, which we know are international law, and some rules or conventions that are seen to rise to that level. So yeah, there's a body of law that it can rely upon to interpret and pass judgment on. Georgia?
So if there's no real punishment because there's no like police to police it or anything, what is the drive to kind of follow the rules for every state if there's no real punishment?
Well, punishment for what though?
Like if you break a treaty or I don't know, just don't follow one of the customs that they have, what happens?
Oh, they'll impose sanctions. They again, because if you go before the ICJ and you agree to be bound by their whatever they adjudicate, then they have the authority to impose sanctions. So sanctions are almost always monetary. So they'll impose fines.
Oh, okay.
And they can order restitution. So if one state has somehow caused a great deal of environmental harm to another state, then they basically say you're going to have to repair that harm. You're going to have to compensate those who've been harmed by whatever you've done wrong. They have that kind of authority. When it comes to things like punishment, right? Where, for instance, if a crime has been committed, and Norette mentioned this briefly, you have the International Criminal Court for that, right? And that sits in The Hague as well. The Criminal Court is a totally different body, and it deals with things like genocide and what have you. Okay, so I've got two more hands up. So who we got?
So I'll go quick. Okay. How does this affect the U.S. relations, seeing that they're not a part of this court? They're not signatory to this body.
Yeah, they don't agree. They don't agree to be bound. Well, the International Criminal Court, they don't agree to be bound by it. They do agree to be bound by the ICJ, the International Court of Justice, which is a civil court. They don't have a problem with that, but they don't agree to be part of the International Criminal Court because there's been, over the course of time, there's been a lot of allegations against American presidents, most particularly George W. Bush and Tony Blair in 2006 with the war in Iraq, with the totally manufactured weapons of mass destruction that didn't exist. And most countries, and including Canada, because Jean Chrétien was the prime minister at the time and he refused to go along with it, saw this potentially as a war crime. So the United States isn't going to participate with the International Criminal Court because it doesn't want to basically atone to its jurisdiction.
Okay, part B, Miles. How does this affect the relationship now in the China Sea, where that's an international dispute and the US wants to get in it, but they're not a signatory to that system there, who are the ones who start trying to fix that issue there? How how does that validate their say in it or their effort to reduce China's influence in that area?
Well, you know, China and the U.S. are both permanent members of the Security Council. They can still, you know, without any reference to the International Criminal Court, they can still bring their disputes to the UN.
Okay.
You know, and it doesn't have to be the International Court of Justice. They can you know, make motions or resolutions for the UN to adopt. The problem, of course, is that they both have vetoes, so that's going to be a big problem. But you know, the UN is a body that will still hear disputes between the U.S. and China. Somebody else had a hand up? Joy?
Yes, hello. Hi. When you were sort of just mentioned earlier about when there were moments when Canada was sort of on the defensive end, would that be when I was reading in the textbook, would that be when we were, I guess, refusing the international agreement to control mercury and basically obstructed the option of a proposal to add crystalline, sorry, I have terrible eyesight, crystalline, yeah, and to control mercury. Was that what you were sort of referencing there? Just so I know.
That's one of them. That wasn't the specific things I was thinking about, but yeah, absolutely. There are times when Canada has not been particularly proactive or enlightened when it deals with things that come before the UN. As much as we think we are, it's often we aren't.
All right, thank you.
Sure, Joy. Okay.
I have a question.
Sure.
What kind of like culminates the ICJ like to make a non-biased group? Like, does each party that's in it vote a constituent to it, or like who creates the International Court of Justice? So it's non-biased. So it's like a non-biased.
Yeah, they're elected. They're elected by the 193 members of the UN. No two members can be from the same state at the same time, right? So they actually hold elections for that purpose. I don't know. I think their periods, their terms are 9 years. I think that's what the video said. So they rotate through. So in any 1 year, and there's about 15 members of the court sitting. So in any 1 year, there's going to be 2 or 3 members who are going to be leaving, and they're going to be replaced by people being elected in their stead. So yeah, it's an open competition. Anything else? All right, guys. So that's the ICJ to a great degree. So again, it has 2 purposes, though. Again, it will adjudicate disputes between member states. The other thing it can do is it can give legal advice on questions when it's asked to by the UN, either the General Assembly or the Security Council. So it can be asked, it can be given a question, as in, here's a set of facts. What would the position, at international law or the interpretation of this treaty or this convention, what would you find to be the appropriate answer to this question? And that's the other function it has. It's exactly the same kind of function, for instance, the Supreme Court of Canada has. So the Supreme Court of Canada, just like the ICJ, it adjudicates disputes between parties, but it also has an advisory role to answer questions. They're called references. So if the federal cabinet in Ottawa had a particular question that it wanted an answer from the Supreme Court of Canada without it being some kind of a dispute between 2 parties or more, it can put a question to the court and the court will answer it. The last time that happened was probably 15, 20 years ago, and it was a question to the court saying, basically it was the referendum, the sovereignty referendum on how, if Quebec wanted to leave Canada, and you guys are too young for this, but that was a big issue in the 60s and 70s, was Quebec leaving Canada. And the question that was put to the Supreme Court was, if the referendum was held in Quebec to decide if it's going to leave Canada, what would the percentage of the population be in order for that to be a valid referendum to which the rest of Canada would have to basically, obligingly agree to? And the answer was 50% plus 1. That was what the court came back with. But it also said 50% plus 1, but that's a very bare minimum of a rule. It should also involve meaningful discussion and dialogue with the other provinces and the federal government. But that's the kind of question that, you know, Supreme Court deals with. And that's the same kind of question that the ICJ can deal with by questions put forward to it by the General Assembly or the Security Council. Alrighty, so what's the relevance of international law to Canadian environmental law? Well, there's a number of ways that it's applicable. So it can provide a mechanism for the federal government to negotiate with provinces, again, where there's constitutional authority, giving them the authority to deal with an issue like, for instance, oceans is a federal responsibility, and waterways kind of thing. So, you know, the example is the Great Lakes Water Quality Agreement with the United States. So that's a federal initiative between two countries, but it very much affects the provinces in Canada that touch on the Great Lakes and those states in the US that touch on the Great Lakes to the south of us. So that's international law that basically is, as we can see, has a domestic implication within the boundary of Canada. The federal government can also use international environmental commitments to encourage provincial action for things like climate change. And one of our last classes is going to be dedicated to climate change, so we'll talk some more about that then. Obviously, it's a really important issue, right? The federal government can also obviously enact legislation domestically that brings into effect international law itself. The United Nations Convention on Biological Diversity is one example. Again, the one I gave you earlier, the International Covenant on Civil and Political Rights, a UN document, but it becomes part of Canada's law once it adopts it, all right? We're going to go through a number of international organizations that touch upon environmental issues. But here's a quote that's kind of important, dealing with the UN. So states have, in accordance with the Charter of the United Nations and the principles of international law, the sovereign right to exploit their own resources pursuant to their own environmental policies, and the responsibility to ensure that the activities within the jurisdiction or control do not cause damage to the environment of other states or of areas beyond the limits of national jurisdiction. So that's a quote by somebody talking about the UN system. So again, when you think about, you know, the environment and how it impacts countries independently, again, they're sovereign states, but things like the good neighbor rule we talked about basically obliges states to take into account any harms they potentially can do to other states, right? Treaties are increasingly used for environmental agreements between the states, right? Bilaterally or multilaterally, right? And the reason for that is why? Anybody? Why would you want to have agreements between states be embodied in treaties? Because that's a binding document, right? That's a contract, right? So that creates legal obligations between parties. You also have, in addition to states, you have what are called intergovernmental and non-governmental agencies, NGOs. There's thousands of NGOs around the world. They play a significant role in getting things done between states and within a state in order to get international obligations brought to the fore. The United Nations Environment Program, UNEP, I mentioned that a little bit earlier, certainly offers coordination, advice, and policy guidance within the UN. So that's something that the UN provides to the member states. You have the Organization for Economic Cooperation and Development. That's an incredibly important organization because it deals with economies, and when it comes to the United Nations, for instance, you know, you have a very serious dichotomy between developed states and developing states, right? And you know, the monies that are spent have to take into account the fact that developing states need a great deal of economic activity in order to become a developed state, whereas developed states don't need any of that kind of money, right? So it's really a battle, you know, at the United Nations in its budgeting, for instance, with respect to how much money are these developed states, which are the prime motivators to funding the UN, how much are they going to turn over to developing states, right, that really have very little connection to them directly. And a lot of that is done through the OECD, right? So that's a committee set up to economically coordinate these kind of things between states. You have environmental non-government organizations. So most of you would have heard, obviously, of Greenpeace, Friends of the Earth. The World Wildlife Fund is very well known. So they actively participate in disseminating information. They have a lot of campaigns. You guys would know that Greenpeace is actively involved in basically protests and they'll run their boats, up to huge ocean traveling vehicles of Russia and China, to protest, fish farming and fish factories, that kind of stuff. Anything that and other things that affect the environment. So Greenpeace is very active. So it's more than just providing public information. It's actually taking on a very, very purposeful role. You also have international institutions that are involved protecting Canada and the US, basically. So the number is 50 million people live adjacent to the Great Lakes, most of those being Americans, of course, right? So there's a lot of coordination that has to take place because the Great Lakes, are the largest bodies of fresh water in the world, right? And as a function of that, they're certainly open to contamination in ways that many other countries aren't familiar with or don't care about. For instance, so there's a map of the states. These are all of the jurisdictions that are part of the watershed of the Great Lakes. So you can see over here we're talking about Ontario, Quebec, and Canada, but we have New York, Pennsylvania, Michigan, Ohio, Indiana, Illinois, Wisconsin, and Minnesota. So there's 1, 2, 3, 6, 8 American states that have an interest in the well-being of the Great Lakes, just like Ontario and Quebec. Right? We have concerns for things like pesticide use and forest management, acid rain. We're talking about that in a few minutes. The invasive species, things that that get into flora and destroy it, and issues of sustainability. The Boundary Waters Treaty Act basically was put in place by the International Joint Commission of the United States and Canada, basically, which is an agency that deals directly with water-related conflicts over the Great Lakes and 300 rivers that feed into them, right? So that's how important this kind of thing is, right? It was basically it's found that there's a serious deterioration of water quality on each sides of the boundaries. There's been a lot that's been done over the course of the last 30, 40 years in cleaning up the Great Lakes, but I can tell you when I was your age that there was a lot of concern about pollution, for instance, in Lake Ontario and Lake Erie. Lake Erie is the smallest Great Lake. The pollution was terrible. People didn't want to go in those lakes because they were so badly contaminated. There's been a lot of effort as a function of this bilateral treaty to clean them up, right? And that's from both sides, because the problem is that cities like Buffalo, that are industrial cities, Hamilton on the Canadian side, it's an industrial city, that they traditionally, dispose of their waste into the lake. That's how they get rid of it. Not unlike what I told you the other day about how cities like Toronto get rid of their waste. Their wastewater goes into the lake. That's now filtered, and we now have, a lot of rules with respect to things going into the Great Lakes beyond simply being waste. The Arctic circumpolar environment basically is incredibly important. It's a really, really important part of the world. It's a very vulnerable place because anything that damages the environment or does contamination in the Arctic will do, for the most part, irreparable damage that won't be repaired. It doesn't have the capacity to repair itself as a function of its climate, as a function of the ozone layer being depleted above it. So, that's the Arctic there. And you can see all the countries that have an interest in it. You can see that the country that has the most geographic contact with the Arctic Circle is Russia. And Russia is very, very aggressive with respect to the Arctic, as in putting in stations that are manned by Russian troops to a great degree. Russia's made no questions known about it, that it does not, has every intention to a great degree to claim the Arctic as part of its territorial jurisdiction, right? So that's something that's obviously going to be contested by the United States and Canada. Greenland, which is owned by Denmark, and Sweden and Finland and what have you, right? So nobody agrees with that, but Russia's made it known that that's their intention. Here's a quote from a House of Commons committee, and this again deals with the Arctic. One reason for the vulnerability is that the contaminants persist longer in the Arctic because core temperatures, persistent ice cover, and low levels of solar radiation retard natural degradation processes, which means the degradation is a healing process to a great degree, and that just doesn't happen in the Arctic, fundamentally because of the temperature. Because polar regions receive more ultraviolet radiation due to a naturally thin ozone layer, emission of chlorofluorocarbons have always had the greatest effect in these areas. We'll talk some more about that in a few seconds. All right, so Canada, these are the countries that basically touch on the Arctic: Canada, Russia, the US, Denmark, Sweden, Finland, Iceland, and Norway, formed actually an Arctic Council, right? Algoma University actually belongs to a subcommittee of this Arctic Council dealing, and I'm not sure what the title of it was, but I was just reading it actually today, that we contribute to some kind of educational institute that deals with the Arctic because, you know, we're seen as a northern university in relative terms to Canadian municipalities kind of thing. But our interest in our special mission dealing with indigenous issues goes much further north than just Sault Ste. Marie. And so we have an interest in what goes on in the Arctic, and we contribute. So that's a good thing, right? The Arctic Council's objectives are to coordinate northern environmental monitoring, wildlife preservation management, emergency response programs, and its priority now is climate change. Again, incredibly important because it's something that will do irreparable damage to the ice, especially if the ice disappears. So if anybody has seen, any kind of a documentary on climate change, you're almost always going to see some part of that documentary talk about the eroding ice around the world, and glaciers eroding, which is going to be a problem. We'll talk more about this on the class on climate change. All right, acid rain. Acid rain is an issue that came out fundamentally in the 1980s. It was something that came about as a function of the reaction of sulfur dioxide and nitrogen oxides with rain, hence acid rain, and what it was doing to the environment. So, there's a picture of a forest decimated by acid rain. There's a sea, killing fish, obviously, who live in waters that have been contaminated by acid rain. All right, so it's incredibly, it was an incredibly big issue. Again, it's something that we've done a lot about in the last 30 or 40 years, basically. The difficulty in containing it is that the pollutants associated with acid rain will occur over great distances, and that's because of the traveling of air, obviously, right? In 1995, so again, this is 25 years ago, Canada and 7 provinces came to an agreement to reduce these sulfur dioxide emissions, which causes acid rain. So we've done quite an effective job in doing that. And what it also involved is the modernization of smelters that were emitting the sulfur dioxide into the atmosphere, including Inco, Falconbridge, and here in the Soo, Algoma Steel and Ontario Hydro, which is now Hydro One. Right, so we had a big role to play in that right here in Sault Ste. Marie with the emissions from Algoma Steel, which you can still see. You see the smokestacks, but you'll see those emissions. They used to come out of those smokestacks as black smoke, right? And it's not black any longer. All right, those industries alone accounted for 70% of Ontario's total emissions in 1983. So that's a lot. In 1991, Canada and the US entered into a bilateral air quality agreement, which again was a recognition by the Americans and Canadians on the effect of acid rain. And what that agreement required is for those 2 countries to set objectives and put air pollution reduction measures into place. And they did that, right? As well as, and this again goes back to the Arctic to a great degree, protecting the ozone layer has been an incredibly important thing that needs to take place on an international basis, right? The ozone layer provides a protective filter against harmful ultraviolet radiation. So it's over the entire planet, right? But there are holes in the ozone layer, and a lot of them, again, in the Northern Hemisphere, right? And what happens is that, those holes are created because the ozone layer is vulnerable to decomposition because of notably chlorofluorocarbons, right? And we knew this was scientifically proven, and to a great degree, these were, right? And we've done a lot about this to address it. these were a combination of carbon, hydrogen, chlorine, and fluorine that you'd find in refrigerators. Most air conditioners still have them to a great degree, but mostly you'd find them in aerosol propellants. So, you know, cans like this, like that, right? So, you know, there's the way that fluids emit from cans, whether it's perspiration or air freshener or any of those kind of things today, is fundamentally different than the way they did 30 years ago. So, you know, 30 years ago, you know, they were using chlorofluorocarbons to emit those kind of things from cans like this. Now we don't use that technology. So, you know, that's gone a long way in slowing down the erosion of the ozone layer, right? The Montreal Protocol, incredibly important in 1989, basically set out limitations, you know, given the limitations of the science at the time, heralded the precautionary era at the international level. Again, the precautionary principle we've talked about a couple of times, which again basically says this, that notwithstanding the fact that we do not necessarily have as much science as we may well want to have with respect to potential harms that could be, you know, take place in the environment, we should still put measures in place to do so based upon where we think science will likely go. So what the Montreal Protocol did is it established targets for reductions in the consumption of very specific groups of identified substances that they thought would potentially cause harm, right? So it evolved to include new substances, again, things that hadn't been proven scientifically to be harmful. It included new substances basically on a understanding that, you know, they would very likely cause harm in the future, and most particularly would probably cause harm to the ozone layer, right? And the protocol put in place in 1989 was ratified by 197 parties. So there were everybody at the UN for the most part, and there are some territorial states that don't belong to the UN that signed on to it as well.
Spray the pesticides near the border of the other country. So it's like the good